Judge, I forgot to approach you on this other case. It's Miss Loyola. Judge, she has an AFM in our court, but she has a felony.
So she's on bond for an assault of a family member,
Yes.
on bond for a felony assault of a peace officer, and now you pick up a new case.
And what happened was she went to felony.
Oh, hold on. I don't even think we've done probable cause yet. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with possession of marijuana. You're facing up to $6,000 and/or $2,000 fine.
Thank you, Your Honor. On March 19th, 2025, a law enforcement officer observed a white Chevrolet Silverado ahead of him on the block 12600 block of Wokeland Parkway and ran the license plate through the NCIC TCIC. Registration was shown to be expired as June 2024. A traffic stop was initiated and the law enforcement officer made contact with the defendant, the driver. The law enforcement officer observed a strong odor of marijuana, and the defendant claimed at first she didn't have anything in the motor vehicle, then confessed she had marijuana and several pipes. The defendant was detained. Probable cause search of the motor vehicle was done, and the law enforcement officer located multiple marijuana pipes. The law enforcement officer located a small bag of a leafy green substance and a black bag in the back seat. It was identified as marijuana, and the bag was within arm's reach of the defendant. Total weight of the marijuana was 0.09 ounces.
Since she has a license.
Yes, Your Honor. It does show being
Eligible or
ineligible.
ineligible? Not allowed to drive. You will now be signing an affidavit with me today promising that you're not going to drive. I don't give a rat's behind what your excuses are. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and/or a $500 fine every time you drive. You are on bond for 2 cases. Your first bond violation report was filed in February for you not showing up for testing and not picked up a new case. I now revoke your bond on the assault case.
Judge, if I may,
Please.
she went to felony court, and she was also revoked there. She just spent probably 4 or 5 days there. Is that right? And she's out here, so.
The date I moved was, I was in jail for a traffic ticket and a big call.
I don't know if you heard that, Judge, but the day that she missed court here the first time.
No, I never missed the
You
test.
missed it, that's right. She actually had texted me and she got taken into custody because of a traffic ticket. I have all that. So she was actually on her way to the testing and got picked over, and therefore she couldn't continue to make it there. So she's already been punished for bond felony court, which she spent 5 days in jail last week. When did you get out on that?
Saturday.
Saturdays. And so if we take her in, I know you have every right to, Judge. It seems to me like it's kind of like a double whammy for her, especially for the fact that for that first BVR, she did honestly try to make an attempt to get there. I have the phone records for that, Judge.
When someone tells me something and they repeatedly fail to recognize the conditions that we set forth, for me, it goes in one ear and it goes out the other ear. You telling me something when you get out the doors, you still do whatever the hell you want to do without regard to bond conditions in this court. I'm now revoking your bond. She goes with you. Well, hold on. I need to sign this affidavit so she's not going to drive. And then she goes with you. I'm sorry, John, but it's just one thing after the other.
Do you want to go ahead and issue a new bond, or can I revisit you in about an hour to figure out what we want to do, Judge?
Sure.
You want to do it that way? Okay.
Shh. Keep it down, we got a plea. Huh?
She went to court 16.
She did, or we have to wait till the judge.
Well, hold on a second. You really want to do a probation with Mr. Proctor?
That's what he said, Judge.
You couldn't even stay out of trouble while you're on bond. Why do you actually think that you can make a probation?
Oh, you got someone to.
Yeah, I've heard that before. How many times have I heard that before? How many bond violations have we had, Mr. Proctor? You know, you can lie to me, but you can't lie to yourself. You know, if you think you repeatedly fail to appear for court You repeatedly fail to comply with bond conditions. How on earth do you think that you're going to be able to make probation where you have to do classes, you have to remain clean, you have to report once a month? You can't even report to court once a month. How are you going to do this for 12 months? History says otherwise, Mr. Proctor. Can we do a TRS on you? Before I do anything, I don't know how to go forward with him. And I think that probably the best way to see is to have Mr. Proctor evaluated to see what conditions and what is the appropriate way to go forward, because I have no idea what's going on in your life. I have no idea what you have, and we don't want to see you fail, Mr. Proctor. We want you to leave better than you came. But just doing this right here, it's just throwing you out there to the wolves. I mean, if you really think that this is the appropriate way, you can even, while you're on bond, for a couple months, stay out. Before, I would like to have him evaluated. So what we do is we have clinicians available that can interview you, talk to you about you, what's going on with your life, what has been happening with you, how everything has transpired and how we've gotten here to this point, and to see what's the best way that we go forward. Do we need a treatment plan? Do we need inpatient treatment? Is it sufficient to do out? I don't know, but I'm not ready to do this just yet. I think that we need to have the QRAS to see how we go forward. Let's see what they say, and then at that point, you want to court reporter regardless, right?
Oh, no, sir. No, sir. We will respectfully honor the
So let's,
request by the court.
it doesn't have to take long. I can expedite it so we can have everything done within the next couple of days. We're not talking weeks. We're not talking, so we can have everything done quick. Because I don't want you to just sit there and languish. But I need to know how to go forward. And this, I don't think that this is the appropriate way. If they say after we have you evaluated, if they say and they give the blessing, then I'm all for it. I want to do what they advise because they know best. Every time I have someone TRAS and I deviate from it, we pay dearly. So that's why I trust them to give us the best advice as how to go forward. All right? Give me a couple days. Let me get the TRAS done. We can come back and then we'll go forward. Okay?
Thank you, Judge.
Thank you. I just want to make sure I have it on my day. So we're just going to wait for the TRAS before we do the plea.
Right. Yeah, because I want to know what are the appropriate conditions that we put, because this right now, this is the type of probation that we usually do when people have, no violations or, they've been, but here we have multiple, 4 different violations from one thing or the other. So that's why.
Thank you,
Thanks.
Judge.
Okay.
Yes, sir. Thank you.
Hey, Your Honor.
Sheila.
I'm approaching on Mr. Portillo Sanchez.
Judge, was presumptively positive for alcohol, fentanyl, and cocaine.
Your Honor, he wants to take a plea for 180 days today, which he's got 22 days credit, so.
I don't know.
All right.
I think the last time we had said a year, right?
Yeah.
We set it for trial, I think, on the 22nd-ish, and he wants to plead to 180. No, okay. Will you accept, is there anything the court would accept? No.
I'm over and over and over. And I don't know if that's what it is that's causing everything in all these cases. But I have a sneaky suspicion that it could be due to all that. You now tested positive for cocaine, fentanyl, what else?
An alcohol, Judge.
Alcohol. You were on bond for 5 different violent cases. Goes with you. I'm sorry, Mr. Portillo. What I would like to do, because obviously now we now know that there may be a more substantive issue that may be causing all this. So what I'd like to do is have him TRAS to see how we go forward. But I'm not going to just continue to take these cases where we're basically pleading guilty, throwing him in there 30 days, gets out, he picks up another felony. We have now 4 or 5 open felonies. No, I'm not going to continue to perpetuate this revolving door of you picking up a case, getting out, picking up a case, getting out, picking up a case, and now you now get to the root of what the problem is and why you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, now 15. It ends today. Goes with you? And we'll have him to your ass. Let's see what it says. And then, you know, but I'm not just going to continue to do the same thing in hopes that when he gets out. So, send it for TRAS. We'll come back in a couple of days, get the report, and let's see what they say on how it goes. Okay. But I'm not going to just continue to do the same thing and hope for a unicorn because it's just not going to happen. You know?
You can come on the call.
I would like to just,
It's up to you.
I would like,
Want to?
I mean, if,
Can,
I-
but
right,
let's figure out what's going on.
sure. I just want to see what I mean,
Sure.
obviously as his attorney, I need to see what his options are and meet with
And I don't
him.
want you to do anything you are not kosher or not happy with, you know? Before we do anything, you know, of course I want your blessing. And if he says no to what they say, then we just go
Have a
try.
try.
And we'll go one after the other. Just be ready, please. Okay.
Should we, I guess, set him like for Friday or something and see, I don't know.
It's probably gonna be the process today. I don't know if it's tomorrow.
You know, there's no way. It's now 11:30. Till tomorrow, he's still gonna be processing.
Right.
So we can't start the TRAS until he's out. Latest will probably be Wednesday is when we get it done. I would say we probably will have the report.
I'm just gonna wait on mine.
Well, but he'll be set for bail review automatically, right? For Wednesday or?
But if he stays in holdover, somebody can come over there.
We usually have people come here to do the TRAS here.
Right, okay.
Here, to
Okay.
try to expedite it so that they don't sit there for a week or
Sure.
2 weeks, you know, because we want to, it's not the idea, it's just to hold, just for the sake of holding, is to get it done quick so you guys can make the informed decision quick. And we'll see, you know, and the idea is hopefully he's honest and then try to get to the cause because,
The option.
you know, before there's a murder case because he's using and he does something that's irreparable, you know?
I
I
understand.
mean, how many times have we seen it? So, okay.
Thank you.
Tiger,
This is Mayor Pooch.
Sorry, Judge, I just have,
man,
I'm terrible. I am in this death penalty capital, so I just don't.
still?
Yes, Your Honor, we're 2 out of 3 weeks. I just have 4 minutes left on my bathroom break. Mr. Thomas tested, it looks like his marijuana levels are going down, but he did test positive for alcohol. I
Talk
talked,
to Mr. Thomas.
he's present, Judge.
Not only have I reinstated his bond once already, but now we're working a second bond violation for it. What do I need to do to get your attention, Mr. Thomas?
Got it.
Yeah, right. Justin,
Yes, Your Honor.
what do I need to do? Put his butt in jail?
I think we've been in felony court this morning, so I don't want you to think he wasn't here. He was,
I don't
he was,
care.
um,
I care about him continuing to use and continuing to do whatever the hell he wants to do without regard to bond conditions. You do what you want to do. I think I have but one choice, Justin, and to just put him in jail.
Judge, what do you think about some AA meetings or some,
I don't think it'll. When did we order him not to use?
What was the last name again, Judge?
This is Thomas, Mr. Thomas.
Conditions were set in place on October 11th.
This past October, we told him not to use.
The marijuana is negligible, so it's almost out of the system. It was at 0.005, I think. I understand the court's frustration and concern.
If it's been bond conditions since October, we're now nearly April 1st. It's been 6 months. So it should have been way, way gone.
No, it was from the positive. So you admonished him on the positive not to use, and then, so this was his first test since,
February 6th.
right, and so that's what I'm saying. So the marijuana is negligible. I know it's not an excuse, but I don't know that we read all of our bond conditions about alcohol. Now, I know that's not an excuse because he signed for it. I get it. But I do want to point out to the court that the marijuana is basically out of the system. It was like, that's why I'd asked for the levels, but it was like at a 0.05 or 0.005. It was,
Alicia, do you see that?
The levels, Judge, let me see if it's in the email.
it was, I asked for them, Judge.
I know. I saw that you did. What do you do for a living? Where do you work?
So it's pizzeria. I'm a chef.
What is it?
So it's pizzeria. I'm a chef.
He's a chef at Russo's Pizzeria, and we're in school. So we are being productive members of society.
How do I know that? Am I supposed to take your word for it?
You can take his mom's, Judge. I talk to his mom pretty much on a regular basis.
Judge, if you see that number, however, truthfully, I don't know what that means. But it is a low number. So that's all I have to offer for, but.
Here's what we're going to do, is I'm putting a scram monitor on his ankle, so I know that he's not consuming alcohol.
Yes, sir.
I'm now going to put a GPS monitor and I'm giving you a curfew, because I don't want you out in the middle of the night. I'm giving you a 10 p.m. curfew. If you ever have another bond violation, I'm going to revoke your bond and I'm going to make it so high. Do you understand?
Sure.
I'm sorry.
I will test you again in 2 weeks. If you test positive for marijuana after 2 weeks, then that tells me that you've continued to use, and I'm going to lock you up. Do you understand?
Sure.
Thank you, Judge. Maybe excuse to go back to very important cases.
Yeah, so he's back in 2 weeks to test. If he tests positive after the 0.05 nanograms or whatever the hell it is, if he's still testing positive.
I have
then
nothing
that's it.
left to say, Judge.
All right.
I will be speechless.
All right.
Your Honor, I am here on Mr. John C. Joseph, alleged BBR violation, Judge. Sitting over in the jury box. It's my understanding that he left his area curfew area on 9:07 p.m. on 5/20 came back at 9:31, approximately 24 minutes. I spoke with him. It's my understanding that he went over to his sister's house because he and his girlfriend had gotten into a heated discussion. He informed me.
Mr. Joseph.
He informed me that he left to stop proceeding the assault, or possibly assault between the two.
I do everything in my power to try to prevent people from going back into custody. But some people just refuse to just, I don't know what I can do to get your attention. You now have 2 open cases, and now this is your second bond violation. What do I need to do to get your, what do I need to do to get your attention? Is it putting you back in jail, Mr. Joseph, and making your bond high? Sir. Your actions tell me different. This is what we're going to do. I'm sending him now for a drug and alcohol test. I want to know what, if anything, is in the system. You were to come back. If you fail to test, if you fail to take the test, if you fail to come back, it's not going to go well for you. Do you understand? I don't want you to say anything. I want you to go take.
I'm offended. I don't have time for it to get on my system.
You have been on bond, Mr. Joseph.
I think the last time he was in court, Judge, I think he made an admission that he had used drugs during that court appearance. And if that's the case, he may be correct in that it may still be in his system, Your Honor, because it hasn't been 30 days.
The first burglary of a motor vehicle has been open since June of 2024. Since that time, I have told you not to use.
Okay.
Take a seat for me. I don't know what we're gonna do. Take a seat.
Thank you, Judge.
You were here in June last year. Because you came in late then. Now we have another set of bond violation for you coming in late.
Was he,
Why would I continue to let you go? I let you go already once and you did it again.
instead of going up, we'll put it on Thursday.
Do you see what I mean? Because me, if I let you go, then I'm telling you it's okay for you to do what you're doing, when it's not.
Judge, if I may, I believe that he has a legitimate reason. I believe that if he had not gone, there was the possibility that an assault or some other harm could have happened to his girlfriend. From my conversation with Mr. Joseph, he informed me that he left, and it was just for only 24 minutes. He left in order for both of those parties to cool down before a fight or an act of violence escalated between those two parties. I personally think that that was the right thing to do.
Who do you live with at home?
My girlfriend, but my sister stay right down the sidewalk in the same apartments.
You stay in a complex.
Yes, sir.
She doesn't live with you.
Huh?
She doesn't live with you.
No, not my sister.
So who is the fight with?
It's my understanding that it was his girlfriend.
Is it the family here?
My girlfriend here.
So the fight was with who?
It wasn't a fight, it was a words that was about to escalate into a fight, at which time he left for a cooling off period with his girlfriend. And he left, nothing serious could have happened. I believe that was, even though it was a violation of the bond condition, I believe that it could have been worse had he not left.
If you put your hands on anyone, I don't care who it is, if it's a woman, if it's a man, I'm gonna put my hands all over you. You understand?
Yes, sir.
Nothing in this life can justify you putting your hands on anyone. You have two.
I just left so the situation can cool down.
You have two open cases. At all times, you need to be thinking to yourself, if I do this, what's going to happen? If I say this, what's going to happen? If you're going to antagonize, meaning if you're going to say something that makes someone flip out on you and the laws come over and they see you and they look you up, 9 times out of 10, they're going to go against you. You need to be thinking of these things at all times. You get into a fight with them, words, it's always going to end up bad for you. I understand and I appreciate de-escalating the situation, meaning you're leaving so that it doesn't end up in anything more. But it shouldn't be like that in the first place. Are you working?
No, I just did 3 job applications. I'm waiting on the interview to begin.
Judge, yes, sir. I know you are.
I don't care.
I do, Judge.
Why aren't you working?
I just recently started looking for jobs.
You have too much time on your hands. You need something to do in this life before it takes you down. When you have too much time on your hands, you become self-destructive. You need something to do in this life. It's time for you to start working. And I want to see that you get a job. Toria, can we help him out?
Yes, I'll give them some resources.
We're going to give you resources to try to help you get a job. There's no reason why you can't have a job within the next couple weeks if you try. When you put your heart and soul into it, you can achieve damn near anything. It's just how badly do you want it? That's what it amounts to. And when you do get a job, if you really do a bang up job, and if you do well and you don't do stuff half-assed, all you're going to do is you're going to go up and you will make more money. The higher you go up in a job, the more money you're going to make. And then everybody's happy. When you get to buy nice things, that's what life's about. Not the janky, stupid ass jobs where you're making $6 an hour. No. Work hard so you can make a lot of money. All right.
It's great.
I'm not going to ding you. I don't want any more issues. Do you understand, Mr. Joseph?
Yes, sir.
I'm bringing you back in 2 weeks, and I want to see that you have a job. 2 to 3 weeks. If I see that you haven't put any effort into it, it's not going to go well between us. I also don't want you to use any dope. Do you understand?
Yes, sir.
If I find that you're testing positive, likewise, it won't go well for you. All right, Mr. D.
Thank you, Your Honor.
Good. Good morning, Ms. Dixon. Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one.
Yes, Your Honor. On February 24th, 2024, at approximately 11:27 a.m., the officer did a license plate check on a vehicle that was shown to be registered to have active Class B warrants out of Montgomery County for driving while license invalid, and 6 Class C warrants from Humboldt Police Department. The registered owner was shown to be a Black female, and that female was seen driving the vehicle through the lower driver's side window, giving the officer reason to believe that the registered owner was currently driving that vehicle at the time. A traffic stop was initiated. The officer made contact with the defendant, who was identified by her Texas driver's license. The officer ran the defendant's information and showed that her license was ineligible and that she did not have any confirmed insurance. The Montgomery County Sheriff's Office and Humboldt PD confirmed the warrants.
Hey, can you run her license down?
Yes, Your Honor. It is not eligible right
And
now.
Ms. Dixon, I'm
Yes,
going to
sir.
find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive. I do not care what's going on in your life. If you do not have a Texas driver license and liability insurance in your name, you are not allowed to drive. If I find that you do, I will revoke your bond, put you in jail. Do you understand?
I have one question.
Stop. This is not the time for that. If you need, I can provide you a lawyer today, but this isn't where you just get to start asking questions. It's number one. Number two, this is a court. When you come to court, please dress appropriately, okay? So I'll have you go fill out an application with Miranda. I'm going to have you sign a receipt with Victoria. I'll have you take a seat in the jury box while we get your bond conditions, and then we'll have you speak to the lawyer here in the material. Please. How's Jen? Really? It's good? Fun?
No, it's really not, but I'm blessed to be alive.
Well, that's a good attitude to have. That really is, because it could be a lot worse. You could always be 6 feet under, right?
Right.
Your lawyer is asking me to set you a bond, but I'm really concerned. This case is very old, and you've been out literally, she's been on the lam for 10 years, Dave?
Well, the warrant was on November 9, 2015 for this one, Judge. But the surrender for the judgment roll was on, well, actually, the enrollment date was February 16th, but the surrender notice to file was April 2020. So I don't know what kind of efforts they went, but the actual forfeiture date was in 2015.
Do you know, do they really want, are they going to
I
come?
mean, that's, like with the other ones, I can only confirm the initial teletype confirming that the warrant is valid and they do still want her.
We've tried to reach out to, I'm sorry, Mr. Kim has tried to reach out to the demanding jurisdiction to see how serious of a case is it? Are they really going to come back? But he's been unable to reach anyone. And I mean, it's only been, 30, 45 minutes. So, your lawyer's asking me to set you a bond. Because of the nature of the case, the type of case it is, and because of the age of the case, you're asking for.
Your Honor, the state's asking for $10,000 because it is a possession of controlled substance with intent for oxycodone, and the fact that it's been in forfeiture status since 2015. This isn't one where it's a to-be warrant. It's one where she appeared in front of a judge, stated she would return, and then she didn't do that.
You want
$1,500, Judge. My client has expressed to me that she is a college student. She has expressed to me that she only works for, because she's in school, Uber and DoorDash. She has expressed to me that she has an attorney that is working because she doesn't want this behind her. She can't have this when she graduates in May, if I'm not mistaken. I have explained to her the ramifications if this court was to give her the bond, that she has to either, that attorney either has to get her a date set there or she has to go turn herself in within the 14 days. She does not have any other criminal history or connections that were dismissed or otherwise, except for this one case from 2015.
You know, the thing is that I have to set your bond sufficiently high so that you understand that we mean business. I'm not going to play this game with you again. If I set you a bond, it's only going to be one time. I won't do it again. You need to understand that there are serious consequences with the actions that you take now. I'm going to set you a bond. I'll set your bond at 5,000. And if and when you make bond, we give you 2 weeks from the date of your release to go turn yourself in to that jurisdiction where you're wanted from. Mr. Kim, where is it?
It's in Mississippi, Harrison County.
Go. So you have to go turn yourself in. If you fail to do that, I will revoke this bond. I'm going to set it at 0. I will issue a nationwide warrant for your arrest. Obviously, I mean, you can't run forever, right? We're going to get you again. And this time I will physically hold you until Louisiana comes and gets you. Do you understand?
I do, Your Honor.
Okay.
So just knowing that, he has made the bond for $5,000, is that something that you can, or you or your family is able to post? Because if not.
5,000 cash?
It's 5,000.
Oh, no, I have a deaf baby. I'm a single parent. My husband died 3.5 years ago. I'm on a fixed income. That's why I do DoorDash, and that's why I do Uber on the side, just to help, you know.
So I said that to say that the waiver, if he sets the bond, then the waiver goes away. They don't come and get you. You don't get to have the bond and wait for them at the same time and see which one happens first. So if you're not going to be able to pay the money, then you can, the option is to leave the waiver that you have in place that you signed on, I think 2/27, and then let them see if they're going to come get you or not. But your time, you don't lose the time that you've already been in custody.
So when you buy, I'm confused, when you behind.
What did she waive?
Right off that, 227?
February 27th.
So you have 1, 2, 3, 4, 5, 6 days credit. We give them 14 days to come get you. If they don't come get you within the 14 days, we release you. They file a dismissal, I sign it, and then they let you go. If that happens, the warrant will always remain active. And that warrant will always remain active until you physically go back or somehow go back to Louisiana and take care of it. That said, if you want to make this bond, you have to withdraw that waiver that you have, and then you lose those 6 days. So if you withdraw it and you don't make the bond, you lose all that time. And you basically, it's told until you re-waive or you make that bond.
I only say this because of the age of the case and the fact that I didn't know she had counsel in Mississippi. It's very, very rare, but I have been seeing it happen here and there, is if local counsel there can get a new setting date. Like I said, it's incredibly rare. I can count on one hand the amount of times it's happened.
What do you mean, get a new setting date?
So even if they don't appear with sufficient evidence from our sheriff's office that she's in our custody and her persons is here, and for a variety of factors, I can't speak to Mississippi because I'm not licensed there and I don't work there, is whatever sufficient factors they have to set a new date for her to self-surrender versus outside of the fugitive, they'll recall the warrant. So like I said, it's incredibly, incredibly rare, but only because of the age of the warrant and the fact that she has counsel there.
Well, but we don't know that.
Well, but I'm saying if the information for that counsel can be sent to.
I mean, I'm not going to give you a PR bond. This case is 10 years old. You've been I need you to understand that we mean business. I'm not here to play games. And so that's why we have to set it sufficiently high so that you realize that you have to have skin in the game so that we know that you're going to go back. I'll let you guys talk about it. I don't want you to make a decision here in front of everybody. So you guys talk about it. You know, I'm not stuck on the 5,000. I go back down a little bit, but it's not going to be much, you know, but
I'll stand down. Thank you, Judge.
So hopefully,
Yeah.
so
Yes, sir.
I'll let you guys go talk.
Okay.
I want you to say something here that you might invariably regret because it's in front of everyone, you know? Okay, please.
Thank you, Judge.
Thank you,
I'll
Judge.
go down some, you know, but a reasonable amount. All right. Mr. Lumumba, you are charged with 2 counts of driving while intoxicated. You've worked out an agreement. They're going to dismiss one in exchange for your plea on the other one. Pleading on 089. This one is, you know, they're all both 08. The agreement that you have is 180 days in jail to be probated for 15 months. As part of the agreement, you will do a DWI education class. You will do 3 victim impact panels. Substance abuse treatment. You will also do what's called a TRAS. The TRAS is an evaluation to see what other conditions you may need. They will probably, because the fact that you have 2 open DWIs, they will probably add other conditions. It may be supportive outpatient treatment. It may be intensive outpatient treatment. I don't know. It may be inpatient. I have no idea. You must fulfill whatever other conditions they assess on you. No drugs, no alcohol. A guardian interlock. 25 hours of community service. Is this how you understand the agreement?
Yes, sir.
You need to understand that one of these will go on your record. The other one is going to be dismissed. But because of the fact that you have at least one of these going on your record, officers will always see this forever. It doesn't matter where you are, whether you're here, whether you're in Maryland, whether you're Alaska. And if you get pulled over, an officer, first thing they do is they run your license. They're going to see the car and they smell alcohol on you. What do you think they're going to do?
Pull me out
Not just pull you out.
and breathalyze.
And what?
Arrest me.
Probably. I don't know for sure. But chances are they're going to see DWI. If they come up to you, they smell alcohol, it's probably not going to go well for you. So if I were you, even if you've had a sip of alcohol, don't get into a car because you're playing Russian roulette with your life. Do you understand?
Yes, Judge.
You're giving up the right to a trial, right to compel witnesses, protection to be had, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you are done with this forever. You can never change this. Do you understand? This is what you want to do. How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I'm going to find you guilty. I will send it to the agreement. I'm not going to suspend your license because you're taking the probation today. I don't know what DPS is going to do. They may suspend it. They may not. So do you know if his license is eligible now?
So, Your Honor, it looks like he has a New Hampshire license, driver's license, but it does appear to be eligible out of New Hampshire.
Which one?
New Hampshire.
Anyway, so if your license is not valid at this point, you are not allowed to drive. You need to get permission from us. You're going to be signing an affidavit with us today promising us you're not going to drive. Do you understand?
Yes.
You said it was?
It is eligible.
It is.
Oh, it is eligible.
Yes, Your Honor, it's eligible. It's an eligible New Hampshire driver's license.
Okay, as long as you have a valid license and you have liability insurance. So you must have car insurance. If you don't have car insurance, you're not allowed to drive. Do you understand? The other thing that you need is that if you're going to drive in whatever car you drive, you must have an interlock in it. Do you understand?
Yes, Judge.
So if I find that you don't have an interlock, it goes in lockout because you failed to pay for it. I'm going to issue a warrant for your arrest. If you don't remain in compliance with this, like you don't do your stuff on time, I'm going to issue a warrant for your arrest. If you're living in Maryland and I have to issue a warrant for your arrest and they pick you up in Maryland, holy moly, you're going to sit in jail for a very long time. So If you ever have any problems, you need to get in contact with Will. You need to get in contact with the Shatoria, because if not, and it goes into warrant status and you get picked up on it, you're going to be sitting for a long time. Do you understand? It takes forever in a day to extradite someone from another state to here. I mean, we're talking weeks. Do you understand? I'm not asking much. All I want my street safe. That's it. All right. How do you plead to the WI? Guilty or not guilty?
Guilty.
I'm going to find you guilty. Like I said, I'll follow the agreement. Your other case will be dismissed. Good luck to you, sir.
Thank you.
Are you working now? What are you doing with yourself?
I found about in Maine.
Okay.
And yeah,
You're working currently.
yeah.
Okay. It's never about the money. I could give a rat's ass about the money. I don't care about the money. I'm going to waive all your fees. Okay. I don't care about the money. But what I care about is public safety. I'm now taking off around probably, $6,000 in fines and fees off you now, Mr. Labuma.
Thank you, sir.
But if you pick up another DWI, if I see you pick up another DWI, from now on, you're facing not only a minimum of 30 days in jail, but a second DWI, it's a $6,000 surcharge. Get a clue. It's not hard. Good luck.
Thank you.
Thank you. We are done. You were Miss Smith,
Yes, sir.
and you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am. Okay.
On February 1st, 2025, officers initiated a traffic stop on a blue Nissan Altima with an obscured license plate at the 13,000 block of Kirklandell Road in Harris County, Texas. The officer made contact with the driver and observed an odor of marijuana coming from the vehicle. The officer identified the driver and ran the ID and found that the defendant had an outstanding warrant out of Bell County and was taken into custody. The defendant stated that there was probably marijuana in the vehicle, but it was not her vehicle. The officer performed a probable cause search of the vehicle due to the odor of marijuana and found 0.275 ounces of a green leafy substance that the officer recognized from training and experience to be marijuana. It was found in the center console of the vehicle.
What was she taken in for,
Her warrant
So she
out
had a
of
warrant
Bell
out of-
County, I can run it and see what the offense is.
And then also if you can run her license plate.
Yes, Your Honor.
She does not have a driver's license.
Okay. Ms. Smith, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive any vehicle whatsoever. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. These are part of your bond conditions. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Judge, I'm not seeing any active cases. What I am seeing is that she was on probation out of Bell County for possession of marijuana. So it might be a probation violation.
Ms. Smith, do you have the ability to hire a lawyer?
No.
Okay, I'll have you fill out an application. We'll see whether you qualify for an appointed lawyer. If you do, I'll provide you a lawyer today. Do not pick up any new cases. Above all else, do not drive. I don't care what's going on in your life. You cannot justify getting in a car and driving for any reason. Do you understand?
Yes, sir.
Okay, Deputy Miranda's going to give you an application. I'll have you I'll have you sign a receipt with Victoria and then we'll have you take your signature. Ms. Hill, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 180 days in jail to be probated for 12 months. As part of this agreement for you to successfully complete this, you must do a DWI education class, 3 victim impact panels. You must also do a TRAS, which is an evaluation to see if you need other conditions. If they assess other conditions, you must fulfill those as well. No drugs, no alcohol, no breath test refusal, meaning if you're pulled over in a car, an officer asks you to submit a breath test, you must do it. If you don't, you're in violation of this probation. No drugs, no alcohol, and a guardian interlock. Is this how you understand it?
Yes.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this is a contract that we're entering into. You either complete it successfully. If you don't, I will issue a warrant for your arrest. You're looking at 180 days in jail. Do you understand?
Yes, sir.
You must do stuff on time. The other thing you need to understand that this DWI will go on your record. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. The other thing is this, is if you get pulled over, I don't care if it's today, tomorrow, 5 years, 10 years, officers will see that you have a prior DWI. If you smell like alcohol, it's probably not going to go well for you. So I would never, even if whatever you're doing, even have a sip of wine, I wouldn't get into a car. It's a huge risk. Do you understand? How do you plead to the offense of driving while intoxicated now? I'm going to find you guilty. I will follow the agreement, send you to it. What do you do for a living, man?
Judge, if I may, before we get to that, regarding the interlock, she does not have a car. She has not been driving. She's been operating under a no driving affidavit. I asked her today if she's going to get a car. I think she's still scared to get behind the wheel of the car. Chief said that we can talk about that condition here today.
Okay, so you need to understand that if you're not going to drive, then, I mean, we're not going to put an interlock if you're not going to drive, but you must have a portable device. You have to understand, though, is that we send orders to DPS in Austin so that every officer in the state knows that if you get pulled over, you're driving a car, you're supposed to have an interlock. If you don't, they're going to arrest you on the spot. So when you say that you're not going to drive, I really, really hope you're not driving, because if you do, it's just not going to go well for you. Do you understand?
Yes, sir.
You will be signing an affidavit with us today promising us you're not going to drive while you're on this probation. If you do eventually get a car and you want to, you can. I'm not going to suspend your license today. So I don't know about the ALR hearing, but if you have a license, the only restriction you have is you must have an interlock. So if you want to, you let us know, let your probation officer know, you get the interlock, and then you're free to drive. But don't drive until you get permission.
Yes, sir.
You understand? So what do you do for a living?
I do citizen work with customer service for health insurance.
The reason I'm asking you this, ma'am, is that there is a $3,000 surcharge that is normally tacked on to DWIs. It's huge business in the state. Anytime you pick up a DWI, it costs you a lot of money. We all make mistakes, but if you continue to, well, you endanger other people's lives. It gets so much worse. What I'm trying to tell you is I'm going to waive the $3,000 fee that normally would apply to you. You pick up another DWI, though, it's a $6,000 fee. Do you understand? Not to mention a minimum of 30 days in jail. Just don't get into a car. It's really easy. Even if you've had a sit, that's it. All right.
Thank you, Judge.
Good luck to you, man. Thanks,
Thank you,
man.
Thank you.
Yes, ma'am.
Are we waiving all of them or just?
So reduce it, and then we'll kill the 3,000, and then run the court costs as well. All right. Good luck, Ms. Hill. So you're charged with false report to a peace officer or to a police officer. You're facing up to a year in jail, up to 6 months in jail, and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Your Honor, on January 17th, 2025, officers were assigned to an auto theft case. The initial police report was taken by a deputy who spoke with the defendant, who stated that he rented a 2023 Toyota Camry from Toro. The defendant stated that he was going out with his friends when he parked the car at a Walmart in Humble on January 16th. When he returned on the 17th, the vehicle was missing. The officer made contact with the witness, who stated that on January 15th, she observed a post on Craigslist for the vehicle. The witness met with the seller on January 16th at a Walmart, which is in Fort Bend County, and the witness purchased the vehicle for $16,000 in cash and collected a title and bill of sale. The witness attempted to title the vehicle when she learned that the vehicle's title was fictitious and that the vehicle was stolen. Another witness stated that she rented the vehicle from the defendant on January 13th and it was to be returned on January 17th. That witness stated that the vehicle was equipped with a GPS and tracking device. The officer observed the defendant's car was never near the Humboldt area on January 16th, but it said it was in Southwest Houston, near the Richmond and Rosenberg area. The officer contacted the defendant again and asked where he parked his car so that he could look at the surveillance footage at the Walmart location. The defendant struggled to answer the question and stated that he parked in the back left of the parking lot. The officer then attempted to contact the defendant again to come in and provide a statement, but the defendant did not answer or return any of the officer's phone calls.
So you said he reported the car stolen
Yes, Your Honor.
on
On find the
the
date.
16th, right? I think you said.
He said that the vehicle was stolen on the 17th.
17th. So did he try to negotiate a sale as well?
Let's see who the seller is.
So let me ask you this. She
Yes, Your Honor.
purchased the car for how much? And did she give
$6,000?
and did she give that amount of money to?
Yes, in cash, Judge.
Did she get the money back?
I haven't been able to speak with her yet, because it's out of Fort Bend, so it's
It's okay. So that transaction happened in a different county?
Fort Bend, yes.
Okay, so that's wouldn't concern us here.
Yes.
Right, okay. All right, Mr. Burris, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? If I find that you do, then I'm going to revoke your bond, put you in jail. I will do everything in my power to protect this county at all costs. Do you understand, sir?
Yes, sir.
I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Can you run his license to see if he has a valid Texas driver license, please?
Yes, Your Honor. It is eligible, Your Honor.
I'd like you guys to please, if you don't mind, do a rip.
Yes, Your
See if
Honor.
there's any restitution that's available in this case. Okay, I want to make sure that every party is made whole in this one way or the other. Okay, please. Mr. Burris, do you have the ability to hire a lawyer?
No.
Are you working these days?
Yes.
What do you do for, what I'll do is I'll have you fill out an application. I'll see whether you qualify for an appointed lawyer. First, I'll have you go to Victoria, sign a reset. After that, I'll have you take your seat at the jury box. So we'll get your bond conditions. Do not leave until you sign our bond conditions. Do you understand?
Yes, sir.
I will protect my county at all costs, Mr. Burris. If I find that you pick up a new case, if I find that you're a danger to my county, I will protect it at all costs. Do you understand?
Yes, sir.
Okay, come on.